Good evening, everybody, and welcome to Know Your Rights. This week we're going to be talking about the Second Amendment. Your prep work for this class should have been to send me Second Amendment videos. We didn't have a huge response on that this time. So next time, please try and do a better job of that. Your homework this time is to send me videos about searches and seizures. We'll talk about this at the end of class too, but notably this is not going to include things on Miranda warnings. We're going to talk about that later on. That's your rights, like you have the right to remain silent. Anything you say can and will be used against you. For this one, we just want to focus on searching for things or people and seizing things or people. The learning objectives for today are to be able to explain what the Second Amendment actually means and understand the confusion that exists around it. And guys, this is a big issue right now because we are currently in the middle of a change with respect to that. And specifically, we're going to get to that near the end of class, but there's a recent United States Supreme Court decision that sort of upends what we thought we knew about the Second Amendment. So let's start by looking at and discussing some of the videos you all submitted.
Rule published in the Federal Register further threatens the rights of law-abiding citizens. It treats individuals who own pistols with stabilizing braces as if they possess illegal short-barrel rifles, and it forces them to surrender them to the federal government. If they don't surrender them, they're retroactively declared criminals for what was then a lawful purchase, and they now face up to 10 years in prison and a $250,000 fine. This is just another example of the Washington knows best elites who are out of touch with everyday Americans. So I introduced the Pistol Act to block the ATF from redefining pistol braces as short-barreled rifles. My legislation provides a simple statutory definition of a pistol and would prevent the Biden administration from improperly classifying pistol braces or regulating them by decree or fiat. The Second Amendment is not subject to bureaucratic interpretation, and we've got to continue to fight to protect the God-given, constitutionally protected rights of all Americans. And I yield back, Madam Speaker.
I said it before and I'll say it again. Self-preservation transcends identity politics. I don't care who you are, black, white, yellow, green, cisgender, trigender, pina colada gender, right, left, Democrat, Republican, gay, straight, bi-curious, pansexual, homophobe. When the time comes to protect your life, all of these political post-it note identities will go out the window. And if a gun is there to save your life, you will use that gun to save your life. And if a gun's there to save and protect somebody that you love, you will use that gun to save and protect somebody that you love. The biggest con played on society today is the idea that your social or political identity should dictate your stance on the Second Amendment. We can have 62 genders and 95 sexual preferences, but a libertarian Asian transsexual who is also pro-gun is somehow where we draw the line. Think about it. We don't do this with any other constitutional right. Constitutional rights are constitutional rights. We don't question the validity or use of the Fourth Amendment simply because of someone's race or religious status. They have a Fourth Amendment right regardless of their identity. So why are we allowing people to dictate our beliefs of the Second Amendment based on our social political identities? Being pro-Second Amendment is not a conservative stance. It is an American stance. And at this point in society, being pro-Second Amendment should be a given. Sure, we can disagree on some of the finer points regarding the Second Amendment, but this idea that you can't be a pro-2A liberal or pro-2A because you're Muslim or pro-2A because you're black, white, Latin, Asian, what name you, is phenomenally stupid. The preservation of life transcends all of it. And the Second Amendment exists for two reasons and only two reasons: the preservation of a free state and the preservation of life, period. It's not about hunting or sport shooting or any of that. It's about putting people in the best position to protect what they value most: a tyrannical government-free life. Right now, there's a culture war against the Second Amendment, which is why I need your help spreading our message to counter their message. You can do this by leaving a comment, sharing this video, and click the bell and subscribe button. Let my voice be your voice, and let them know you want to keep America tactical. Because the right to keep and bear arms shall not be infringed wasn't a suggestion, it was a...
So what's strange about that is that the first two videos here are a belief that a lot of Americans share. Um, I want to point out, and I'm going to link a John Oliver video at the end of this from when he was working on The Daily Show. So while it is a comedy piece at heart, it really kind of illustrates the fact that other countries have struggled with gun violence as well, only they kind of have taken a different approach. This is famous most recently for legislators who have been advocating for arming teachers. They think that the solution to school violence is to give teachers guns. Um, you know, I'm not going to wade into that political debate because it is a hotbed of issues, but there are different options that exist, and giving people guns or how we handle gun control is simply one of the possibilities. Let's look at the last video that is a great segue into the major cases we're going to discuss this afternoon.
Gun rights and the Second Amendment were front and center at the Supreme Court today. As John Yang reports, it is the first major test of gun regulations since the court said that gun ownership was a right protected by the Constitution.
While the Supreme Court has said the Constitution gives Americans the right to keep a gun at home, gun rights advocates say that should apply outside the home as well.
The Second Amendment doesn't end at your doorstep.
Tom King is president of the New York State Rifle and Pistol Association.
I think that someone who is not otherwise prohibited should be issued a concealed carry permit without any problems at all.
King's group sued New York on behalf of two upstate members who were both denied unlimited concealed carry permits for self-defense because officials said they didn't prove they needed them.
And they were turned down for no reason at all. Okay, no reason given other than I don't think that you need it.
When the Supreme Court recognized an individual right to gun ownership in 2008, the ruling, written by the late Justice Antonin Scalia, acknowledged that the right secured by the Second Amendment is not unlimited. Gun control backers argue that limits are needed to protect another right. Chris Brown, president of the advocacy group Brady.
It's about the right to live, about our ability as Americans to walk down the street, to leave our homes, to go to church, to go to synagogue, and actually be able not to fear being shot. That's ultimately what's at stake in this case.
While King, a member of the National Rifle Association's board of directors, said that big city gun laws do little to curb violent crime, Brown says that licensing systems like New York State's do.
States that don't have robust permitting systems have on average, at minimum, about a 12% increase or spike in gun-related violence in those states. These permitting systems work.
New York is one of 8 states plus the District of Columbia that require gun owners to prove a need for a concealed carry permit. Some of today's oral arguments focused on the history of gun regulation in America, which the court had used to establish the right to gun ownership. Justice Sonia Sotomayor pressed the attorney arguing for the gun group on which history was relevant.
In colonial America, at least 4, if not 5 states restricted concealed arms. After the Civil War, there were many, many more states, some included in their constitution, that you can have a right to arms but not concealed. I don't know how I get past all that history without you sort of making it up and saying there's a right to control states that has never been exercised in the entire history of the United States, as to how far they can go in saying this poses a danger.
Chief Justice John Roberts asked one of the attorneys arguing in support of the New York law why someone should have to show a special need to exercise a constitutional right.
So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right? You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise the right, I think, is unusual in the context of the Bill of Rights.
That showed one indication that the Chief Justice is thinking that, there's something not quite right here about what's going on.
Marcia Coyle, chief Washington correspondent for the National Law Journal.
The court appeared just as divided as they were in 2008. And in 2008, the court was divided over what the right in the Second Amendment meant. But this time, they're looking at what is the scope of that right.
Roberts and other justices pushed the gun owner's attorney on whether the right to bear arms extends everywhere. The New York City subway, crowded football stadiums, Times Square on New Year's Eve.
This is why this case is difficult. There is this balance between public safety and a constitutional right.
The court will likely rule by next summer. For the PBS NewsHour, I'm John Yang.
As I said, I've linked to the John Oliver video here. I'm not going to show it. I don't want this video to be taken down. All of this, I believe, falls under fair use. I certainly don't want to show an 18-minute video in its entirety as part of this video. I do encourage you all to watch this. The link's in the notes, like I said. And it's very interesting how in Australia they controlled gun violence, and they did it by the conservatives essentially taking the bull by the horns and making it happen. So the case we talked about sets up the second case we're going to talk about today, but the first is United States versus Heller. And first we're going to look at the text of the Second Amendment, and then we're going to break it down just like Heller did. And I'm sorry, I said United States versus Heller. It's the District of Columbia versus Heller. In that case, essentially, the District of Columbia had gun control legislation that required you to keep handguns unloaded and in a certain, unaccessible state in order for you to possess them within the city limits. Now, eventually, in that case, the court ruled that that was unconstitutional. You couldn't have a law that required people to not have functional weapons. We will talk about why that's the case in just a second. But let's start by reading through the text of the Second Amendment and then breaking it down. The text reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." When breaking this down, at first glance, a lot of people think, oh, okay, you can possess a gun in relation to service in a militia. The militia having been disbanded and replaced by the National Guard, it would seem like your ability to possess a firearm is limited to your ability to serve in the militia or National Guard. In this case, however, Scalia wrote the opinion of the court, just like they discussed in the video we watched. And what he says is that the well-regulated militia part of that text is the prefatory clause. That means that it indicates a preference, but is not mandatory for the operative clause to take effect. The operative clause, of course, being that second part, the right of the people to keep and bear arms shall not be infringed. But we've got a couple more terms we have to define in order to understand this. The term keep is ruled to mean to possess. It doesn't make sense that you can have arms, though, without being able to use them, and we'll talk about that with us in a second. To bear means to carry about, or to brandish, or to basically have. If you can have the gun and you can carry it about, and you can use it for lawful actions like self-defense, what the court rules is that that weapon must be functional. You can't give people the right to have guns, but require that they keep them in some sort of dismantled or locked state. Arms, of course, has been defined to mean essentially any weapon. There are limits on that, but those limits are really called into question, and that's what we're going to talk about with New York State Rifle and Pistol Association Incorporated versus Bruin. This is a very recent Supreme Court case. It just came from last term, and it's kind of nuts, guys. The reason is that it has thrown into flux the whole question of what is and what isn't permissible as far as guns go. While DC versus Heller defined that you have to let people have a gun, and this was the controlling standard for quite some time, the Supreme Court created a new test or a new rule. And in that case, essentially what they hold is that in order for a state to have gun control laws, they have to show that there's some sort of historical gun control law analogous to what's being enacted now. This is huge because, as I'm sure many of you haven't noticed, the country we live in today is vastly different than the country that existed 220 years ago. It simply doesn't make sense to say that, oh yeah, we are going to treat guns the same as we did in the year 1800. In the year 1800, there were a lot more risks and perils around that there are not today. But that historical test is now what's going to be applied. I really encourage you, I've linked the text of the case down below with that blue link in the notes. I really encourage you to take a minute to read that. It's, again, kind of a fascinating case because last term was somewhat explosive. We saw the Supreme Court essentially create two new doctrines, which doesn't typically happen. And we saw the Supreme Court strike a major blow to the right to privacy, which again hasn't happened since its inception, really. This is one of the two new doctrines that were recognized by the court. So please take some time, look over that case. It's very fascinating to see what the court did here. Now, one of the biggest things about the Bruen case is that because of this, a lot of the stuff with respect to the Second Amendment is now in flux. And so realistically, what are your rights when it comes to the Second Amendment? It's trending towards you can do whatever you want for the most part. The terms of the types of weapons you can possess are constantly being challenged. The limitations on where and how you possess guns are constantly being challenged. I don't know when the pendulum will stop swinging. This is typical. Throughout the course of history, we have seen the pendulum swing both ways. On the Second Amendment, on other various issues, but I don't know how far into relaxing gun control and favoring the Second Amendment this is going to go. And realistically, it's one of those things where, how's it going to play out? I don't know. We're going to see how courts interpret the Bruen decision over the next year or so, and that'll really be the guiding factor for this. I'm going to release a video that's kind of like a half video talking about the Third Amendment, just what it is and why we don't really talk about it ever. But I don't expect you guys to do anything with that. For this, I'm going to have the discussion boards posted in just a minute for you to talk about the Second Amendment. But the other thing I need you to do is to upload your videos. I'm sorry, in the notes I usually like to have a embedded link that you can click, or an embedded form you can just drop the video into, but I'm using a new file system, and so you're going to have to click the link and go to the thing and actually do it that way. This is because I'm shutting down my cloud-based file server and saving a whole bunch of money doing that, so I apologize that the technical capabilities aren't quite as good on this new one, but I thank you for your understanding. All right, thank you guys so much. Again, quick lesson, mostly because this is a real gray area. I think one of the main questions, if we go to why this is a misunderstood right, is because it's constantly in flux. And everybody's trying to push it one way or another. When we have things like school shootings, mass shootings in public places, there's going to be people who are calling for gun control. But we also have people that are terrified that this is the first step towards the United States essentially controlling people through some sort of authoritarian government. So how does it end up playing out? Well, only time's going to tell. Wish there was a better answer there, but that's how it shakes down at the moment. Thank you guys so much, and I will talk to you again soon with respect to the Third Amendment.